everyone, it's Aprilia and welcome back to my channel. So today I'm going to tell you about international maritime law, issues and challenges. Okay, sea transportation, overseas trade and etc. existed way before industrialization, and they play a major role in the world's economy to date. This calls for some form of regulation over such affairs. The United Nations Conference on Trade and Development published in its 2018 report that maritime transport is the backbone of world trade and almost 80% of the world trade is seaborne. Ancient maritime rules were traced from the customs of the Egyptians, Greeks, and Phoenicians who conducted extensive trade through the Mediterranean Sea. The earliest maritime code belonged to the Rhodians, and these laws were leveled up by then emerging empire, the Romans. The oldest of the maritime codes found in the Roman law was the Consueto del Mare, or regulation of the sea. All this development contributed to the formulation of the admiralty laws of England. These doctrines were introduced in the colonies of England and later were carried to USA. The contemporary maritime law formulated in the postmodern era contains the doctrine derived from the ancient codes and also various new laws. Since we now got a brief idea about the historical development of maritime law, which is also known as the admiralty law, let us now try to understand contemporary international maritime law. Well, the meaning of maritime law. Maritime law was also called admiralty laws. These laws are a distinct body of private and public laws governing maritime activities such as the shipping agreements, offenses committed in the international waters, marine commerce, issues relating to sea transport, disputes over nautical matters, and etc. The Merriam-Webster Law Dictionary defines maritime law as the law that relates to commerce and navigation on the high seas and other navigable waters, and that is administered by the Admiralty Court. And then the difference between maritime law and the law of the sea. Well, the law of the sea is a set of laws governing in the interaction between nations over maritime matters. These rules have been codified in the 1994 United Nations Convention on the Law of the Sea, or the UNCLOS. Thus, the law of the sea applies to public entities pertaining to maritime issues. The maritime law is a set of laws governing the private entities, like the private ship owners of the ships which travel in the international waters, private shipping agreements relating to international waters, and etc. Well, and then the component of maritime law. The first is maritime liens. In admiral cases, proceeding can be brought either against individual or against maritime property like a vessel or freight, etc. The proceedings against individual are in personam, while those against the maritime property are in rem. Maritime liens constitute a category of proceeding in rem. In a proceeding in rem, the maritime property can be arrested and kept in the custody of the court unless the owner obtains it released by necessary legal procedures. Mostly, in the pragmatic word, the word secures the property to avoid an arrest. And then the second, shipping charters. Various contracts govern shipping service is transportation of cargo through waters. These contracts, which govern the use of ships in international waters, are made by the chapter parties and are of three types. There is Jamis or bareboat charter. In this, the ship owner transfers the possession of the ship to the charterer who act like the owner of the ship during the period of charter. The charterer engages the master and the crew of the ship. And then there is time charter. In this, the ship owner himself employs the master and the crew, while the charterer only has the right to direct the direction of the ship for the transportation of the cargo. And then there is voyage charter. In this, either part or full of the cargo space is rented for a voyage or a series of voyages. Well, the next, number 3, is collision liability. Liability for collision damage is based upon the fault principle, which says that a colliding vessel will not be responsible for damage to another ship or to a fixed object, like a bridge, unless the collision is caused by a deficiency in the colliding vessel or by negligence on the part of its navigators. And then number 4, general average and salvage. It is a doctrine in a maritime law. All the parties in a sea venture will save maritime property from loss or damage. Such parties are entitled to an award for their effort. Also, those whose property has been salvaged in their effort to rescue others' property shall be entitled to compensation from the latter. And then the last one is maritime insurance. Marine insurance aims to protect the maritime property from unforeseen situations that may damage such property. Well, the next is issues and challenges in the international maritime law. The laws may be framed with foresight, but the lacune in their implementation will always be present because of various pragmatic challenges and complexities. The same is the case with the implementation of international maritime law. Weak law enforcement, poor security, political instability, and etc. lead to commission of various offenses in the international waters like piracy, armed robbery at sea, violence at sea, corruption, illegal fishing, smuggling, and etc. In order to address these issues and provide relief to the aggrieved parties, interstate cooperation and just legal enforcement are required. But, sadly, states fail to cooperate most of the time, and justice in terms of maritime law only turns out to be mirage. Well, that's all for today. Thanks for watching. Don't forget to like, comment, and subscribe to the channel. See you in the next video, and bye-bye.